The court denied that request. Well, that's interesting. So the court didn't even allow Maxwell's defense attorney to review the material before they released it. In 1951, the Rosenbergs were tried, convicted, and they were sentenced to death. And they were executed in 1953. Damn, man, that's when we had a country that didn't like traitors and actually did something about it. Look at these ladies. What a nice outing in prison. Man, how often do they get gym time? Doesn't look like that much. Do they get to go outside like once a month or something? Because that's what it looks like. Maxwell responds, and she does not want those transcripts to be released. We know that there was a battle between the public and the courts and the DOJ and the American people about whether we should see what's inside the files. And so Todd Blanche and the Trump Justice Department sent in motions in both cases saying, can you unseal the records? And the judges responded and they said, we got a lot of questions. What records do you mean specifically? Have the victims been contacted? And what is the status of your files? Can you tell us what's in there, what's not in there? Give us some details. And we've had a back and forth. We'll get up to speed on it, but the big news is that Maxwell is now opposing the unsealing. And we gamed this out, and I think it's actually smart from her to position to do it, because if there's useful material in the grand jury transcripts, if those get unsealed and the public is satiated, here you go, we found everything, all right, not much there, then maybe it dies down, everybody moves on, and Maxwell becomes less valuable. But she needs her testimony to matter. It needs to be something of consequence. And so she wants to be the only person with the keys, not the grand jury, Maxwell. So she's opposing it, and she wrote the following into the court. This is in the Southern District of New York, saying, although the government did not oppose allowing the defense to review the material to assess whether we object or not, the court denied that request. Well, that's interesting. So the court didn't even allow Maxwell's defense attorney to review the material before they released it. As a result, Maxwell is not even seeing anything. So she can't even make an informed position. So given that she's actively litigating her case and does not know what is in the record, she has no choice but to respectfully oppose the motion to unseal. Now she jumps right into it. You know, Jeffrey Epstein is dead, probably. Ghislaine Maxwell is not yet, and we hope it stays that way, but a lot of people have some nerves, you know, are those cameras working over there at that minimum security prison? But she's not dead yet, as we know. So whatever interest the public may have in Epstein, the interest cannot justify a broad intrusion, says Maxwell, into the grand jury secrecy in a case where Maxwell's still alive. She still has legal options, and her due process rights remain, saying when Epstein died, prosecutors from New York pivoted, and they made Maxwell the face of his crimes. She became the scapegoat, and the only person the government could put on trial. That's not true at all. The only person that could, or the only person that would. She was convicted in a media firestorm of false reporting and mischaracterization of evidence. And to be fair to Ghislaine, which is kind of a weird thing to say, and you know, we think she's a detestable, reprehensible person, of course, but the point is she responsible, Maxwell, for all of everything? Like, is she the one who really trafficked all of the kids to those other dudes who also abused the young people, the kids, the children? Or is it just very convenient for them to say that she is? And she's the only other co-conspirator, because remember, there were 4 named co-conspirators in Epstein's original plea deal who were in there by name. Their names are there. Nothing happened to them. So if the immunity deal doesn't actually apply, if it only applies to the district in Florida, how come those other 4 women were not prosecuted? Yeah, don't know. Well, we probably know why, because they know that it applies to them by name. But now with her case pending before the Supreme Court, now the government seeks to unseal untested, hearsay-laden grand jury transcripts, which contain statements presented in secret and never challenged in an adversarial process, saying Maxwell has never been allowed to review those transcripts, even though the government did not oppose her recent request to do so. And so the government, which they should be able to review that, like they should absolutely be able to review that. How can they make an informed decision and take a position on it without reviewing it? The government seeks to unseal the grand jury transcripts, citing historical interest without regard for how that's going to impact Maxwell. Now, the memo cloaks itself in another case from Todd Blanche, but that case emphasized that disclosure requires careful judgment and the balancing test. Does the public and their curiosity matter? Grand jury secrecy is very important, and so does public concern and just curiosity outweigh that? Judge will say, of course not. Now, there is a tradition in the United States that's even older than our country that grand jury proceedings are secret. It's in the rules. There are certain exceptions for it. A lot of it's discretionary, but the case that the DOJ is citing is talking about discretion. And yeah, there are some exceptions, but one of these is justifying continued secrecy. And so Maxwell right now, she's before the Supreme Court. Epstein may be dead, but Maxwell's alive and she's litigating her case. She's preparing a habeas petition as we speak. So any disclosure of grand jury materials, even from Maxwell or Epstein's case, risks tainting the legal process by injecting sealed testimony into public debate. The reputational harm alone is irrevocable. And those allegations, if released in raw, would inevitably influence any future legal proceedings should Maxwell succeed in her post-conviction litigation and she gets immunity like the other 4 women in Maxwell's original plea deal. The government's proposal to redact victim identifying information doesn't mitigate this. And so public curiosity, writes Maxwell, is insufficient when her interests are at stake. These factors weigh heavily in favor of preserving the secrecy. Was she going to just take no position? Was she going to agree? Was that part of the deal? Maxwell will take no opposition and will move her to go hang out with Holmes and they can crochet together. All right. But no, she's objecting now. So I don't know what that deal was. Although the government's memorandum sets forth certain aspects and subject matters, Maxwell has never had an opportunity to review the entirety, of the grand jury materials in her case. So they got some of it and, hard to remember what she got and what she didn't get. We wouldn't know that. The government provided a list to the court under seal of witnesses whose accounts were conveyed in the grand jury and a corresponding list noting which witnesses testified at trial. And that list has not been disclosed to us. The government's memo, however, acknowledges the law enforcement witnesses. So in other words, there are some people who presented the grand jury who did not present at trial. They thought we didn't need them or they weren't credible or something. What is that list? They said, well, we're not using them at trial, so you don't need that. The government's memo, however, acknowledges that the law enforcement witnesses who testified before the grand jury are alive. They remain active in FBI and NYPD roles. And so the government's memo also disclosed that many complaining witnesses are also alive. And so you can't release them. There's too many active people. There's too many alleged victims. And none of the cases cited by Todd support this. This other case is involving a grand jury proceeding against Julius and Ethel Rosenberg relating to conspiracy charges because they were providing secrets to the Soviets. In 1951, the Rosenbergs were tried, convicted, and they were sentenced to death. And they were executed in 1953. Damn! Man, that's when we had a country that didn't like traitors and actually did something about it. In 2015, upon a motion by a nonprofit, then they unsealed the records and they noted 65 years had passed and the testimony should be released. Now, it's noteworthy that Hellerstein refused to unseal any of this while he was alive and only did it after he was dead. Similar case in another situation, talking about communism. Hiss maintained his innocence until his death. He said he was being prosecuted by Nixon because he was a communist. Then 50 years later, they unsealed them. But disclosure here, Maxwell's alive. You can only do it after she's dead. Don't give them another reason. Disclosure is being sought due to immense public interest in Jeffrey Epstein. It's not just public interest. It's public interest for a reason, because we doubt the efficacy of our justice system, of the FBI and the DOJ. The public interest, while understandable, is insufficient to warrant disclosure of grand jury. The government frames its interest as historical. And by the way, the DOJ has done this, okay? So the DOJ is not giving them like a good reason. We're not getting a real full-throated, full-effort attempt by the DOJ, because what they're saying is that they've done everything appropriately. We investigated everything. Now, this other case is equally unavailing. In that case, they wanted to unseal a grand jury testimony of a congressman who had not been indicted and had waived any protection to secrecy by seeking disclosure on his own. But they cite another case, and all of the cases they say are bad, okay? There is no precedent for unsealing grand jury transcripts in a case like Maxwell's. She's alive, the other people were dead, and so therefore don't unseal anything. Signed by David Oscar Marcus, who of course is Maxwell's attorney. Now, in addition to that, we also had a letter come in from Todd Blanche and the rest of the team over there, actually from Jay Clayton, who works over there in the Southern District of New York on behalf of Todd Blanche. They said, all right, judges, listen up. I know you wanted more information about what we want you to unseal. In particular, we asked for transcripts from these cases subject to the appropriate redactions. And we were asking, what does that mean? Does that mean transcripts? Does that mean exhibits? Does that mean photos? Does that mean videos? Does that mean notes, pleadings, filings, everything? What's in there? The court directed us. They said, well, I don't know what you're asking for. So can you give us some more information and let us know if the victims are upset about it? Now, on July 31st, the court said you wanted additional information. You wanted the dates of the grand jury presentations. You wanted exhibits shown to grand jurors, whether we wanted them, stating the government moves to unseal exhibits as well as transcripts and identifying with specificity what we want and more. And we also got more requests from you as well. And so here's what our response is. is. We're consolidating this into one response. First, at this time, the Trump DOJ and Todd Blanche has moved only to unseal the transcripts in these cases. That's it. And it's not going to be the Epstein 2007 cases, as far as we know. Of course, grand jury exhibits are not the only exhibits in these cases. A large number of the exhibits were already admitted at the Maxwell trial, which trial exhibits are, subject to redactions and sealing, presumptively public documents. We saw a lot of the photos that were redacted. I mean, like the paintings, and there's redacted, like cylindrical devices, probably, like, jars of liquids, stuff like that. It's all redacted. The public has an especially strong right of access to these things. And so we've already made those trial exhibits public, okay? So they're saying a lot of this is already on a website that we made out available during the Maxwell trial. It was already out there. The government respectfully requests leave of the court to advise the court by August 8th of its position with respect to the exhibits. So we haven't decided on the exhibits yet. We'll let you know. Such timing will permit the government to consider with respect to its positions any redactions, and it will allow us to notify the victims, which are all due by the 5th. Now, second, the Epstein grand jury met on June 18th and July 2nd, 2019. Maxwell met on June 29th, July 8th, and March 29th. So important grand jury dates for those two cases. But notice, we're not talking about anything from 2005, 6, 7, nothing. All of that forgotten about. Third, the government has provided the court with all substantive exhibits from the grand jury presentation in both cases that we have in our possession. Okay, so, and they just got a subpoena for this stuff from Congress. So all of the things in their possession, Congress asked for that. So we'll see if they get it. The government respectfully submits under seal to the judge one additional grand jury exhibit from the Epstein case in its letter to the court that we did not have available at the time. Wonder what that is. Now, fourth, in connection with this letter, the government also submits to another judge under seal and ex parte a version of the Maxwell transcripts where there's information in the transcripts that is not, as far as the government is aware, already publicly available. As previewed in the government submission, many of the victims and witnesses testified at trial consistent with what they said in the grand jury, and so it's basically the same that we presented at trial, mostly the same. And so the enclosed annotated transcripts show that much of the information that was in the grand jury, with the exception of certain victims and witnesses, was also already made public at trial and has otherwise been publicly reported through public statements of victims and witnesses. So we know that this was the point of this whole op, was to sanitize it. Epstein was dead. You button up Maxwell. No one else gets prosecuted, and you say justice was done. Fifth, the substantive grand jury exhibits are not currently part of the public record. The government, however, is undertaking to identify for the court specific portions of the grand jury exhibits that are already in the public record. And so in doing so, the government is going to compare the exhibits against the voluminous public and sealed exhibits offered at the trial to see, and civil litigation dockets to answer the question, is it already public? Because if it is, you don't have to unseal anything. The government requests leave of the court, so we'll respond to this. And second, the null pros, which is an invalidation of a prosecution. You're Latin for we're not going to prosecute you, declining or invalidating or nulling a prosecution, that was filed in the Epstein case does not impact the disclosure. While the Supreme Court has noted in a different context that the court's jurisdiction ends when a null pros is entered, it did so in the context of entering judgments. Now, to the contrary, at least one other court explicitly held that a null pros does not deprive a court of the opportunity to determine whether to disclose grand jury minutes. Now, although there was no public trial of Epstein, the government is also prepared to do a similar analysis in the Epstein case if you want. Right, because we got no exhibits in the Epstein trial because he's dead, because we got no trial. So they ended and terminated the prosecution against him. So, we didn't get any of those exhibits. Some of the Ghislaine stuff we definitely got, but not all of it. So regarding the government's approach to victims, the government has provided notice of unsealing to all but one of the victims. Still been unable to contact this person. With respect to the other victims who are not identified in the transcripts but who have previously received this, we're going to alert them as well. And finally, in light of the government's ongoing efforts to ensure that the interests of the victims and other third parties are appropriately considered, it may be necessary to supplement this, and so we'll do that if necessary. Now, simultaneous to this, we have another battle brewing. Remember, Trump sued the Wall Street Journal and Rupert Murdoch, and he said, I didn't send a pubic hair letter to Jeffrey Epstein, okay, you sick, weird freaks, and don't print that garbage in the media. Well, they did anyways, and Trump sued him. They were getting scheduled for depositions, but looks like those are being postponed. What we have here is a stipulation, an agreement between the both sides sides. Of course, this is President Trump suing Rupert Murdoch, and now this is being filed. Until the motion to dismiss is adjudicated, the parties agree that we are entering into this stipulation, and we are agreeing, Trump agrees, that he is going to abate his pending motion to compel the deposition of Murdoch. Until their motion to dismiss is adjudicated, we're not going to engage in discovery, but we are going to exchange initial disclosures, and we're going to see if they try to settle this thing out or what, but it will be postponed, signed by Alejandro and George for both sides in this matter. But Maxwell, of course, as we know, got moved to minimum security prison, which is where they have crochet kits now. And even the other prisoners, the other felonious women, are disgusted by her. Like, oh, she's disgusting. So the new prison pals are disgusted that she just got moved over to Club Fed. They're like, those are our crochet kits. The convicted offender was moved from Florida to minimum security. Julie Howell, she's there. She's serving 12 months. Julie Howell apparently is, Theranos is there too. Oh, wow. Look at these ladies. What a nice outing in prison. Man, how often do they get gym time? Doesn't look like that much. Do they get to go outside like once a month or something? Because that's what it looks like. All right, so they're out, and her new prison, like Elizabeth Holmes, she's like, I cannot believe Ghislaine is here. Says minimum security camps are known to be low security, and it's one of the best prisons anyone could go to. It looks nice. It looks pretty. They got headphones and iPods and all sorts of things. But if someone is a cooperating witness, they can go. Maxwell is set to be out of custody in 2037, and people are not happy that she has been moved over there. So this woman is called Julie something or other. She got arrested. This woman right here, Julie Howell, serving a 1-year sentence. It's like, I can't believe I'm in here with this disgusting woman, and it's a curious situation that's happening. Now, what's also interesting is that Hunter Biden and others are talking about this fake lie that Epstein set Trump and Melania up, and scandalous lie. But now the Daily Beast has to retract the story, which is obviously not true. The Daily Beast retracted a story from last week, which alleged First Lady Trump, Melania, was very involved with Epstein. Now, this came out from this other so-called biographer called Michael Wolff, who said during a Saturday podcast interview that Melania was closely associated with Epstein and met Trump in 1998 through ID Models founder Paolo Zampoli, who had ties to Epstein and Maxwell. After publishing the story, Melania's attorney sent a letter over to the Daily Beast saying this is not accurate at all. After the story was published, the Beast received a letter from Melania's attorney challenging the headline and the framing of the article. After reviewing the matter, the Beast has taken down the article and apologizes for any confusion or misunderstanding. It said Melania Trump was very involved with Epstein, and it's all on YouTube still. Wolff accused Melania of knowing Epstein very well. It's still up on YouTube. Scandalous liars. Trump suing, and Congress now demanding answers on it. And we'll keep our eye on this. Thank you for subscribing and joining as we do.